Now, one person we did hear from today for the first time, Karen Reed herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record. Okay, how is everybody? Aidan Turtleboy Kearney says that he was in constant fear during the time of his restraining order. We're going to listen to his testimony in the restraining order hearing that was put on. So his former girlfriend, Lindsay Gattani, got a restraining order against him. She was deeply believed in Karen Reed's innocence, got involved with Aidan Kearney, and has since changed her opinion on Karen Reed. She now believes she's guilty. Aidan Kearney thinks it's just all about him and an affront to him, her change in opinion on the Karen Reed case. And we listened to every part of the hearing. Not every part, most parts of the hearing, let's put it that way, except his testimony. So today we're going to listen to his testimony. Let me just pull it up. How is everybody doing today? Okay, I hope.
We are here regarding sitting at the desk right in front of you here.
Yes, I do.
And who is?
So we listened to Mary Bagwell's testimony. We're going to circle back to her in a minute. Innocence Fraud Watch found more inconsistent statements in Mary Bagwell's. Speaking of someone who's switched sides, who's changed their opinions. But
I just wanted to disappear. It's hard to explain. And I started walking down the road and
hold on one moment.
Say that at that point when you took up with Ms. Gattani that you were mutually going to end your marriage.
I'd say so, yes.
Now, Ms. Gattani, at the winding down of your relationship, told you that she was pregnant, correct?
That's correct.
And tell us about what happened with respect to the circumstances of that in a nutshell.
She told me that when things started getting bad in the relationship and it seemed like it was going to end, she told me that she was pregnant and I couldn't. Obviously, that made it a lot more difficult to end at that moment. And it caused a lot of anxiety and issues with me, obviously, because I have 2 children and this would obviously cause a lot of issues. the entire time, as it turned out, the whole thing was a lie. And it was causing a lot of mental anguish in my life to the point where one night I had a really bad panic attack. And I started I just wanted to disappear. It's hard to explain. And I started walking down the road and in the dark, and I sent her a video of myself walking down the road in an extreme emotional distress state.
Let me stop you right there. I want to ask you about that. You heard the plaintiff say to the court that you have mental health issues. Where would you say any mental health distress that you have came from?
From her lie about being pregnant. And
now, at some point, you started to stand up to her and break it off. Isn't that right?
So how do you walk down the road in extreme mental distress? So it sounded like from that testimony that the reason he sent the video of him walking down the road in extreme mental distress state is because he wanted her to see his distress. Now, how does one walk down the road showing you're distressed? Is it the look on your face? Do you put your hands to your head? How does one do that? Asking for a friend.
Yeah, once I figured out later on in the relationship where I began to have serious doubts about the pregnancy and she couldn't answer questions for me, I attempted to end the relationship on December 9th.
And you were...
And also, I'm just surprised that this judge, his alarm bells didn't go off when he said that all his mental health issues are from this, what he calls a lie around her pregnancy. That everything was great. He had no mental distress until Lindsay came along. I find that hard to believe. It seems like perfect blame the victim. I wouldn't have to act this way if you didn't make me.
You received a call on the phone from her that day, correct?
I did.
What was the tenor of that conversation from her end?
Very threatening. She said that she wanted, I told her that if she was pregnant, I was worried that the baby would have fetal alcohol syndrome because she drank so much. And she told me that she was going to drop that fetal alcohol baby off of my house and party the effing night away. And then she said that she's going to be my biggest regret, that she will fucking destroy me. And she just basically said, like, if you leave me and don't talk to me, I'm going to ruin you.
That was on a December 9th phone call. Is that right?
That's correct.
Now, sounds like that probably ought to have terminated any contact with this woman.
Yes, we didn't speak for about 10 more days around there.
So what happened with respect to kind of reapproaching each other? How did that happen?
Well, first she attempted to coerce me to come over to her house with the promise of a threesome. That was on December 21st, and I didn't go. And then on December...
Was that through text messages?
That was through text messages, correct.
Yeah, go ahead.
And then on December 22nd, that was the day I was arraigned. And
is that a Friday?
I don't remember the day of the week.
So it was an arraignment in the Superior Court, is that right?
That's correct.
So it's a case where you would have been indicted, is that right?
That's correct.
All right. Did that indictment have anything to do with Ms. Kearney?
No, it's completely independent of her.
All right, go on.
And as soon as I got home, I got a message from her alerting me that she had just been visited by State Police Detective Brian Tully, who is kind of spearheading my case. And he had given her a summons to testify in what appeared to be a grand jury in my case on December 27th.
Were there a couple of things that Ms. Kearney referred to in an effort to have you come to the house?
What do you mean?
So you had this information about a pregnancy at the time. You weren't sure what
Correct.
the status
Yes.
was, is that right?
Yeah, I was still, she was insisting that she was pregnant. And
were you asking her for some sort of corroboration or something?
I was.
Did you ever receive anything?
I received some photographs, including a pregnancy test that had metadata on it showing that the image was taken in May of 2023. I also received a picture that she sent me in late November of what she claimed was her at an abortion clinic in Brookline, she said. I later found out through metadata that that picture was taken on December 4th, 2021. So the pictures she was sending me of evidence of this alleged pregnancy were all old photographs that she had taken from prior pregnancies.
So you have the pregnancy issue, and then you have a subpoena. Is that right?
Correct.
What happened with respect to a subpoena? How did that figure into this?
Well, like I said, the attempts to get me over her apartment with sex wasn't working. And so she sent me this picture of a grand jury summons on.
Wait, I mean, isn't that the way to get any guy over? She just kept inviting me over for sex, and I was like, no, I'm not that kind of guy. Me interested in sex? Not me. Not this guy. Not this guy. Not the. So this is hard to believe.
December 22nd, and said, I want you come over tonight and talk about it. And I said, no. I actually called you and alerted you to it, and you advised me not to go. And so I informed her that I would not be going, at which point she, threatened me and said that, well, if you don't come over, then I'm going to do what I have to do, and I'm going to tell the grand jury about the baby.
So you went over there, and did you try to limit your private?
The grand jury, I would tell the grand jury about the baby. Why would that hurt Aidan Kearney? Sure, he's married, but he just said he was at the end of his marriage. They were already breaking up. So why would her telling the grand jury about the baby be any threat? It doesn't have anything to do with witness harassment and intimidation. That doesn't even make any sense. Is the judge awake? Is the judge awake here? First, I thought it was really fair. And then I listened today and I was like, we really need to educate. I thought to myself, I'll translate. I thought to myself, we really need to educate these judges about coercive control and power dynamics in relationships. Because it'll come into play, I'll point it out when it gets very alarming, if you know anything about coercive control and narcissistic domination, I'd call it, in relationships.
Encounter with her?
So the next day, so I initially told her.
Really narcissistic abuse is my view.
I wasn't going to come. And then early on the 23rd, she then continued to tell me that she was pregnant and that she wanted to discuss that. And so she'd also told me that she had been speaking with a woman by the name of Kate Peter, who was antagonistic towards me, and that she wanted to come clean, and she said, and show me all the messages in her phone. And so I agreed to do so. I told her I want to meet in the conference room because I don't really trust you right now. And the police have been in your apartment. I don't trust them. So I'd like to meet you in a common area. And so we sat in a common area for 2 hours in her Medfield apartment. And
what were you doing during that 2 hours?
Well, we began to look through her phone in the common area, but she started receiving phone calls from her son, it was a lot of phone calls, and this had never happened before. And he called like 7 or 8 times, insisting that she come back into the apartment.
So the kids were up in her apartment?
That's correct.
How old are the kids?
2, 3, 5, and 11, or 12 at the time, I think.
So what happened with respect to you trying to stay in the common area or go into her apartment?
So she said, that I have to go in there now. Just come in here. Everything's going to be fine. And so I said, okay. And we went into her apartment. We continued to look at her phone. I never once touched the phone. She held it the entire time. And I took notes about.
We continued to look at her phone. This is what I found very alarming. I wanted to see her phone. You don't have the right to demand to look at anyone's phone if this is not a legal issue. Do you know what I'm saying? On a personal level, someone you're dating has no rights to your phone. And this, to me, shows that he thinks he owns her and owns every piece of her. And you're going to, and he demanded to see her phone, and we were looking through the phone. How did she held the phone and scrolled through it and I took notes? It doesn't sound like anything possibly realistic in my view, but okay. Sounds like he demanded to see her phone and looked through it and took notes. How does she hold her? She holds it up and like, okay, can you scroll back? Hold on, I'm not done with, and he took notes. And then he's going to say, I was alarmed by some of the things he found in her phone. Because Aidan, so sensitive, he was alarmed by the things in her phone. So moral and sensitive, was alarmed by the things he found in her phone. Okay, just going to go back so we can listen to that part again.
I'm working. And so she sent me this picture of a grand jury summons on December 22nd and said, I want you come over tonight and talk about it. And I said, no, I actually called you and alerted you to it. And you advised me not to go. And so I informed her that I would not be going, at which point she, threatened me and said that, well, if you don't come over, then I'm going to do what I have to do. And I'm going to tell the grand jury about the baby.
So you went over there, and did you try to limit your private encounter with her?
So the next day, so I initially told her I wasn't going to come. And then early on the 23rd, she then continued to tell me that she was pregnant and that she wanted to discuss that. And so she'd also told me that she had been speaking with a woman by the name of Kate Peter, who was antagonistic towards me, and that she wanted to come clean, and she said, and show me all the messages in her phone. And so I agreed to do so. I told her I want to meet in the conference room because I don't really trust you right now. And the police have been in your apartment. I don't trust them.
That's what she wanted, to come clean and just open up her phone for him. This sounds like a cult leader. Sounds like Keith Raniere. Sounds like Larry Ray. I feel like I'm back in the courtroom listening to testimony in the Larry Ray trial or Keith Raniere, both cult leaders. She wanted to show me her phone. She's dying to show me every personal aspect of her social life. Just dying to scroll through her phone while I took notes because she wanted to do the right thing. This is narcissistic psychopath cult leader stuff.
So I'd like to meet you in a common area. And so we sat in the common area for 2 hours in her Medfield apartment. And
what were you doing during that 2 hours?
Well, we began to look through her phone in the common area, but she started receiving phone calls from her son, it was a lot of phone calls, and this had never happened before. And he called like 7 or 8 times, insisting that she come back into the apartment.
So the kids were up in her apartment?
That's correct.
How old are the kids?
2, 3, 5, and 11, or 12 at the time, I think.
So what happened with respect to you trying to stay in the common area or go into her apartment?
So she said, that I have to go in there now. Just come in here. Everything's going to be fine. And so I said, okay. And
all right. I'm sorry, guys, but I have to take a quick break. I will be back in 1 minute. Don't go anywhere.
A glass of wine. Roberta will be back in no time. This podcast is listener supported, so smash that like button and subscribe, or become a patron for exclusive content if you are so inclined. Have something to say? Shoot Roberta a super chat. She will do her best to read it on air without delay. Now Roberta's back and ready to put the true back in true crime. Here's Roberta.
Okay, thank you for sticking with me. If you're just tuning in, we're listening to Aidan Kearney, Aidan Turtleboy Kearney's testimony in the hearing to extend the restraining order brought by Lindsay, the ex-girlfriend of Aidan Kearney.
We went into her apartment. We continued to look at her phone. I never once touched the phone. She held it the entire time. And I took notes about what was in her phone. I was shocked and horrified about some of the things that I was seeing. And then at about 2:30 or...
So just born yesterday, Aidan Kearney. Couldn't believe some of the things he saw on her phone. I'm not going to say what they were. They're actually too terrible to describe.
3 o'clock, we were done, and we were intimate. And shortly after that, it was Christmas Eve morning at this point, and I had to go home.
So it's like December 24th, like 3, 4 in the morning?
That's correct, about 3 in the morning. And I wanted to go home. And the best way I can describe it is she lost her mind. She snapped. And she said, "You can't leave me." And she then took what she claimed was an abortion pill, even though she wasn't pregnant. And said, "Now you can't leave me here. You can't make me do this abortion by myself." And I said, "I have to go home. It's Christmas Eve and you're not pregnant." And she then told me, she then woke up all 4 of her kids, started screaming at them manically, and said, taking their coats out and saying, "We're going to drive to Aidan's house so I can have an abortion in the driveway. And if I bleed out..."
This sounds like from the mind of Aidan Kearney, but or embellished, to say the least. Hey, Heisenberg. His lawyer said Lindsay's reasons are not confirmed in the law. When this is all said and done, I foresee the laws changing in a big way down the road. His lawyer, wait, let me read that again. His lawyer said Lindsay's reasons are not confirmed in the law. Confined. I knew. Is there something wrong? My apologies. Reasons are not confined in the law. When this is all said and done. Confined in the law. When this is all said and done, I foresee the laws changing. Hopefully, I don't think there's enough education about narcissistic abuse, my opinion. You know, when I was at the Nexium trial and the Larry Ray trial, it was actually the same doctor who really educated the jury about how what is commonly seen in relationships between abusers and victims and coercive control. It was actually the same doctor. Excellent testimony. And that's what I think we need to do with our judges, is really educate them. Because anytime you hear she wanted to show me her phone, she was totally holding her phone and I was taking notes. And it's not that he demanded. It sounds like what he did is he demanded to see her phone and then took all these notes from it for information to use against her later. And this is why my opinion, that he basically won this hearing. For one, she didn't have a lawyer, so it's not really a fair fight. But 2 is that he kept all the receipts and she just came in thinking the truth is enough. And sometimes in the court of law, the truth is not enough. Or her truth, whatever. I don't know. I don't even want to say her truth. There's only one truth. But I know what happened to me. I'll just say what happened to me. It's not enough. You really have to keep records, bring records with you so you can prove what you're saying. And what Karen Reed is so good at And Aidan Kearney psychopaths is making their own evidence. They think like a lawyer, which is also thinking like a criminal. Heisenberg says his lawyer said Lindsay's... Oh, wait, I'm just reading that again. Sorry. I don't know how that just popped up. Okay.
Out and crash my car along the way, then it's going to be his fault. You know, she frequently had done this before, threatening to kill herself and leave notes blaming me.
In response to hearing that display, what did you do?
I agreed reluctantly once the 5-year-old came out, and he just had a look of horror on his face. It's something I'll never forget. And for the sake of the children who I thought were in danger if she actually followed me to my house, I agreed to sit. She wanted me to stay for 3 hours. And so I sat on her couch until around 5 a.m. When she finally fell asleep. And then I walked out of the apartment and I drove home.
Did you assault her?
Absolutely not.
Did you throw her on the couch?
Absolutely not.
Did you grab her wrist?
Absolutely not.
Did you get in a struggle over pieces of paper?
Absolutely not.
Did she lock herself in the bathroom at some point in the evening?
Yeah, she did at one point go into the bathroom.
Absolutely not. Statement analysis would say is not no.
The next day, you later learn that she went to the police actually came to her, right?
Yeah, according to the police report, she called State Police Detective Brian Tully at around 11 o'clock.
She didn't call her town police?
No, she actually called Cape Peter for several hours. And we don't know what they discussed, but they spoke on the phone for a couple hours.
And you know this from discovery in your case, correct?
That's correct.
And the call to Detective Tully is the detective or the lead detective on the case that you were just indicted for, right?
Yes, he's lead
Arraigned
detective.
the
That's
day
correct.
before.
And the can't read case.
Nothing to do with Medfield police, nothing to do with domestic violence, correct?
Nothing.
To your knowledge, and you're having all the discovery in the case, to your knowledge, did Ms. Gattani ever call 911 or call her local police department or anything to that effect?
No, Brian Tully did.
And what happened with respect to Mr. Detective Tully calling the local police? Again, based on the discovery, what did you learn happened?
That Detective Tully called the police, and he's the one that told them that an allegation of assault, that she's claiming that she was assaulted. She never told them that initially.
Tammie, thanks so much for the super chat. Why didn't Lindsay have an attorney with her? I don't think she could afford one, which is why there is a Give, Send, Go. I'll put the link. I was really pleased to see so many of you give to it last night about Lindsay. Hold on one second. Let me pull it up. Here we go. Okay, back to Turtleboy. Thanks so much, Tammie. Nice to see you. Pats to Gizmo. Here it is. So
And so the Medfield police came to her apartment on Christmas Eve and spoke to her. And then she then told this story about me stealing paper from, or her stealing paper from me, and then me assaulting her because of that.
And that resulted, just to put a quick point on it, that results in charges against you. You come to this court, you get your bail revoked.
So he got his bail revoked because the court believed that happened. They found her credible, that he put hands on her over these pieces of paper.
For 90 days, you end up being in jail starting on Christmas, the day before Christmas.
Day after.
Day after Christmas, sorry. You're in court on your birthday and you get your bail revoked and you're in jail for, the order was 90 days, but we got it back to 60 days, correct?
Yeah, I was incarcerated for 60 days.
And with respect to the incarceration, your mom was ill at the time, was she not?
She had pancreatic cancer.
And that was two months out of her life that you were deprived of, and she's since passed away, isn't that right?
She died in June.
So with respect to engaging in any kind
You can look at what Aidan Kearney was doing when his mother was sick. And he was on lives. He was constantly out and about, tweeting. It looked like he devoted himself totally to free Karen Reed. So it wasn't Lindsay keeping him away from his mother. It was his own priorities. I mean, just take a look at his actions around that time.
Conduct whatsoever that may have ever created a reasonable fear of imminent serious bodily harm. Is there anything you can think of that you may have ever done to her that could ever satisfy that standard?
Nothing.
Did you ever create any revenge porn accounts against Mr. Kearney?
Absolutely not.
Did you record Ms. Kearney in this alarming evening that you described for the court? Did you resort to recording Ms. Kearney's outbursts, shall we say?
I did.
Why'd you do that?
Because I was scared for the children and I wanted to do it for my own protection.
Did you tell her?
Yes, I told her. I alerted her. That's correct.
And you have those tapes, correct?
I do.
Then fast forwarding, Ms. Kearney brings this February 26th, 2024 restraining order violation case, correct?
That's right.
Or she's involved in it, I should say, Judge. She's involved in that case, right?
That's correct.
So that case, taking the allegation there as it is, doesn't allege any violence or anything whatsoever relative to creating bodily harm. Isn't that right?
Yeah, that's right.
The allegation there is that you were in a certain proximity, correct?
Yeah, and then I yelled, liar, liar.
Judge, that's all I have. Thank you very much.
All right, so we still have cross-examination and closings. It's 1 o'clock right now, so we're going to take the luncheon recess. We will resume promptly at 2 p.m. At 2 p.m., ma'am, you may inquire of this witness. Thank you.
Thank you, Judge.
2 o'clock.
Court, all rise.
Under the year of the order, how has that affected your actions, your behavior, your mental state?
I live in constant fear of going back to jail due to the existence of this order and her history of attempting to weaponize the order to trigger a violation.
He lives in constant fear. Yet he walked right by her. And actually, no, that was Kate Peter. He's trying to. Remember that? Does anybody remember when he walked by Kate Peter and said, she's got to move. I have a restraining order against her. And the cop wrote a report saying he went out of his way to antagonize her and walk in front of her. Does anybody remember that? So, excuse me for... he has a lot of fears. He's in fear of going back to prison. He's in fear of Kate Peter. Needs a restraining order to keep himself
constantly in
safe.
fear that she's going to show up at my kids' basketball games and my kids' soccer games because she's shown up at so many places before. On June 28th, she showed up at I was outside the courthouse supporting Karen Reed, and she barged through, the group that I was with. And I literally had to run for safety and find a police officer and say, there's a person here who has an order against me, and I want to document this and film.
He literally had to. He couldn't wait to. He had to run to safety and get a police officer. I find this hard to believe. Anyone else?
And let you know I am walking away. I'm trying to stay away from her. I'm just constantly in fear because of the existence of this order. And I have to see a therapist. The 60 days away was extremely traumatizing. I have 2 young children who didn't know where I was for 60 days.
Really? He sees a therapist? He's seeing a therapist. It's working about as well as Woody Allen. Doesn't seem to be helping.
Days, and on March 14th, we had another bail revocation hearing 20 days after I got out of jail. And I found out that they wanted to send me back for 120 days because she showed up to where I was at the courthouse on February 26th.
The incident we discussed here about you having to leave court.
That's right. And I left and I went to where a police officer told me. And I just remember thinking, like, where can I go that's safe? I just signed up to be my kid's basketball coach. And I had to actually think, like, what if I go to jail? Who's going to coach the team? Like, should I even do this? Because I'm constantly living in fear because of the existence of this order.
Do you have any interest at all in engaging her, provoking her, being anywhere near her, assaulting her, harming her, talking to her?
No, I want to be as far away from her as possible.
Thank you.
All right, thank you, counsel. So, ma'am, this is your opportunity to inquire whenever you're ready.
That's why he talks about her constantly. He wants to be as far away as possible, but constantly engaging and taunting her. Unreal.
Mr. Carney, you're charged with violating this order, and there's a pending criminal case in this very court for that, correct?
That's correct.
And I am the named victim in that pending criminal case. Isn't that correct?
That's correct.
And separate to that, you also have an open felony case in the Norfolk Superior Court related to the charges of wiretapping and witness intimidation against me, correct?
That's correct.
I'm also the named victim in those pending felony matters as well, correct?
That's correct.
You're also facing numerous other felonies in regards to witness intimidation and other charges, correct?
That's correct.
With other separate witnesses, correct?
That's correct.
Mr. Carney, do you remember? Or let's see, straight that. Episode 645 of your YouTube show on March 12th. You said the following, didn't you? And I'm quoting you. And hopefully that continues on Thursday because I don't want to go back to jail. That would suck, especially over some bullshit lies. This shit needs to end, man. This shit needs to end. But I got a great attorney and a great defense team, and we're gonna fight hard and we're gonna win. We're gonna take them down, man. I'm not going to jail. Fuck that. I already did my time. If they send me back to jail, I know it would be somebody's like, yeah, people would riot. People would be fucking outraged because everybody, when I was sent to jail for the first time, you guys didn't know about Lindsay Gattani. You didn't know her. Now you know. You said that, didn't you?
I'd have to hear it.
Another episode, didn't you also say, who's the scary one? Me or them? Me? I'm the one that knocks, motherfucker. They should be 1,000,000 times more scared of me than I will ever be of them because I'm a relentless, vengeful cunt, hell-bent on putting them all in prison. If that doesn't scare the shit out of you, what does? And I got a large platform to do it. And I'm fucking smart and savvy and I know what the fuck I'm doing. You said that too, didn't you?
I don't recall saying that.
He doesn't recall. This is what lawyers tell witnesses to do. When they are faced with unflattering material, they don't remember saying it. Their memory goes hazy. Again, this is why it's so important to bring receipts. This is something that John Lewin talked about in cross-examination with Dr. Loftus. It's a technique she uses. I have to see it. I don't remember. And so she assumes that you're not going to have the piece of information, but he had every quote, every statement she ever made. Lindsay Gattani needed to be armed similarly.
Mr. Carney, you mentioned that you sent me a video, which you described as showing you having a panic attack. Is that correct?
That's correct.
And in that video, isn't it true that you were walking down a dark highway, threatening to walk into oncoming traffic because I tried to break up with you? Isn't that correct?
That's incorrect.
Isn't it true that you hung up
Hold on a
after?
minute. Stop.
That's incorrect. Yeah, that's what I'm saying. How do you send a video? I went in walking in extreme distress. How do you walk in extreme distress? Makes me believe Lindsay more, saying that was the purpose of that video, that he was going to walk in, threatening to walk into traffic. Otherwise, I don't understand how you can, unless you're going to sort of be a mime, Head to hands? I don't know. Head to heart? Do you drag your feet? How do you walk in distress? That's what my question.
Take that computer and leave the courtroom. This is the second time I've warned you. I'm going to make this as clear as I can possibly make this, okay? Don't shake your head. Be quiet and listen, okay? What's your name?
Grant Smith-Ellis, Your Honor.
All right. Sir, you did not ask permission to record this. You did not ask permission to videotape these proceedings. You have a laptop open. I can see the light illuminating throughout this proceeding. Don't shake your head. Keep listening, okay? I'm warning you now, okay? If I see you recording, if I see you videotaping in defiance of my previous notification to you not to do so, you'll be fined up to $2,000 and sentenced to up to 90 days in the House of Correction for each contemptuous act that follows. Do you understand that?
Yes, Your Honor.
Okay, take the computer and remove it from the courtroom. You are welcome back in, but the computer is not.
Thank you, Your Honor.
Thank you.
I just want to tell you that, gentleman.
Who is that gentleman they're about to say?
Has nothing to do with the defendant or the defense.
Okay, I don't consider him having anything to do with either party.
Thank you.
I just know he was an individual in the gallery that was recording or attempting to record in an unauthorized fashion.
This happened to me when I was at the Nexium trial, Keith Ranieri's trial. It was the first day of Keith Ranieri's trial, and they had set up, so when you go into the Brooklyn Federal Courthouse, or any federal courthouse in the 3 bureaus, you have to go through like what you do at the airport, a security check. So you put your shoes, I have to put my shoes through because they always go off. My shoes always go off. And whatever else, change, whatever. Then they had a second security check for Keith Raniere because they were that worried that someone would do something because he was so hated. The publicity was so high about everything involved in that trial with the branding, et cetera, et cetera. And the gentleman in front of me tried to sneak in a tape recorder and got busted. He got through the first security check, but he got busted at the second security check in front of me. And they checked his recorder and he could pick it up. Like you have to check your phone on the way. But I was shocked to see that. That's the only time I've ever seen anyone busted for trying to record something.
And he's been warned. Ma'am, you may proceed.
Thank you. Isn't it true that you, after you threatened to walk into oncoming traffic, that you shut your phone off, you hung up and shut your phone off, and called me back an hour later, acting like nothing had ever happened?
That's incorrect.
Isn't it true that this wasn't the first time that you threatened to kill yourself when I tried to break up with you or wouldn't answer your calls?
You've never tried to break up with me.
Didn't you also do this before knowing about my pregnancy? Because you would use that as your excuse for your alleged panic attack.
You were never pregnant.
Isn't it true that you used similar threats with another ex-girlfriend and threatened to kill yourself with an extension cord when she tried to break up with you?
That's incorrect.
Didn't you admit on your YouTube shows about needing to take a break in the past because of your suicidal ideations when you were caught cheating on your wife?
I've had to take a break for mental health issues before.
You claim that I lured you to my house on December 21st for a threesome. Isn't it true that you willingly came to my house on December 20th?
I don't believe he will really ever end it all. He's way too narcissistic. But it's a good way to exert power and control over someone by threatening to end it all.
And had sex with me?
I did.
And if I wanted to set you up, I could have done so then, couldn't I have?
You could have.
I didn't need to lure you to my house because you came over my house willingly to have sex, correct?
Not on the 22nd.
Mr. Carney, you took me to a bar in Norwood in October 2023, isn't that correct?
Well, he's saying that he was turning down her request to come over and get laid. I mean, come on. Come on.
Yes.
Were you aware that night that I only had 2 drinks?
No, you had more than 2 drinks.
After the trip to the bar, you drove me home, isn't that correct?
I did.
During that drive home, I refused to engage in sexual activity with you. Isn't that correct?
That's incorrect. It's not, I didn't ask for it.
Did you not claim on many of your YouTube shows that I, quote, refused to give you roadhead?
On which night are you talking about?
The night in question in October of 2023
Which-
when we went to the bar in Norwood.
Which day? We went a few times.
The night in question when we were driving home, you just answered that you drove me home after the bar. Isn't it true that you stated to your audience that I pretended I had to throw up to get you to pull over to the side of the road?
You were berating me and telling me that.
Isn't it true that you stated that I pretended I had to throw up?
Your objection is sustained. You may finish your answer.
You were berating me, dehumanizing me, telling me I was worthless and what a horrible person I was. And then you said that you had to throw up. And I pulled over, and that is the reason that there was no sexual relations in the car on the ride home.
Isn't it true that after you pulled over and I got out of the car to pretend to throw up, that you stated that I ran down the middle of the street in the dark to try to escape from you?
You were not, you began walking down Route 109 in Westwood in the dark.
Isn't it true that you also stated that a couple in a car pulled over to try to offer me assistance?
That did not happen. I do not recall that happening.
Isn't it also true that you stated that you then persuaded me to get back into your vehicle?
I did not want you to get hit by a car. I was worried about you, so I asked you to get back into the car.
Isn't it true that we then went back to my apartment?
That's correct.
Isn't it true that at that point I was blackout drunk and you raped me?
No, that's incorrect.
Isn't it true that you recorded the rape?
It's incorrect. I did not
Isn't it
rape
true
you.
that you showed the recording of the rape to multiple people?
You showed it to the police and they said it wasn't rape.
That is not what the police stated in the report.
It
Isn't
is.
it true?
Objection to counsel testifying to the plaintiff testifying your own motion straight.
Isn't it true that you got a copy of the rape?
Hold on. As to that last objection, sustained, motion to strike allowed. Next question.
Isn't it true that you got a copy of the police report regarding the rape during the discovery process for your current criminal trial, and you gave it to another person on an anonymous Twitter account to post publicly, completely unredacted, with all of the sexually explicit information and details about the rape and my identifying information?
Objection. Sustained.
Mr. Carney, on February 23rd, you were indicted on the wiretapping and witness intimidation charges. Isn't that correct?
That's correct.
On February 28th, are you aware that I was called to the Medfield Police to answer to false claims of you reporting me for wiretapping?
They were not false claims. You did wiretap me by putting a Ring camera video. In your bedroom and filming us having sex without my consent.
Isn't it true that I was not charged with wiretapping?
Not yet.
Isn't it true that on February 26th, you violated the restraining order, and a mere week later, on March 6th, you then went to the Denton police to file another retaliatory claim against me for filing a false police report?
I never violated the order, and I did go to the Denton police to file a factual false police report against you because you lied in the report by saying that I yelled liar, liar at you when video evidence shows that no such incident occurred.
Mr. Carney, on March 14th, 2024, you had an arraignment for an RO violation and hearing for dangerousness, bail revocation, and just report in front of Judge Pomeroy. On several weeks later, April 11th, you posted and announced on Twitter that you were filing a motion to try to have my restraining order vacated. Isn't that true?
I did file a motion to have the restraining order vacated.
Based on these instances, wouldn't you say it's fair that this tit for tat retaliation has been on your behalf, not mine?
I don't understand the question.
You stated that the Denton police informed you while you were recording that you could stand this is on February 26th, that you could stand on the steps of the Registry of Deeds and that would be fine. Isn't that correct?
He said, go over there. And he
But
pointed.
Mr. Carney, when Officer Crump testified on March 14, 2024 at the Denton District Court, he told the court that at no time that at the time he did not know who you were talking about and where you were talking, where the person was at the time. Isn't that correct?
He told me to go stand over there. So I went to where he told me to stand.
Isn't it correct that he said you should go stand over there for now and then we would figure it out?
He said something to that nature.
Mr. Carney,
correct?
you never followed up with that officer again at any point after that, did you?
Within 5 minutes, the hearing was over.
Mr. Carney, isn't it true that after you followed me to my car, the following day you wrote a blog about me, a very lengthy blog in which you posted numerous pictures of me, videos of me, slandered my name, and made light of the situation?
I never followed you to your car. And I don't make light.
I never followed you to your car, but I did write a slanderous. Now he's gonna say he didn't write a slanderous blog. This is where she should have the blog. You know he's gonna deny all these things. Hopefully she'll have some money for or find a lawyer who will help her out, because she is being sued for $2 million for defamation by Aidan Turtleboy Kearney.
Of any of this.
I have nothing else, Your Honor.
Jamie Director, Attorney Gray.
Yes, Judge. You ever been charged with rape as a result of any allegation from this plaintiff?
I've never even been questioned by police about it.
And you received a police report and discovery about it, correct?
I did.
And the police report goes through all of the texting and the police review of the videotape from the sexual encounter that you had that night with Ms. Gattani, does it not?
The consensual sexual encounter, correct?
And the police reviewed it.
And
Oh,
I had
whoops.
no-
That's my fault. My fault. Sorry, guys. I just started to laugh. But the consensual sexual encounter. Make sure you put consensual in there. Make sure you put consensual in there. Where were we? Oh, let's see if I can figure it out.
And the police review of the videotape from the sexual encounter that you had that night with Ms. Gattani, does it not?
The consensual sexual encounter, correct?
And the police reviewed it, wrote a report on it, talked all about the text exchanges between the two of you, correct?
Correct.
And the police report recreates all of them, doesn't it?
Yes.
And in those texting, she indicates in a nutshell that she doesn't remember the night before, correct?
I believe something of that nature,
As
yes.
opposed to that she didn't consent to the night before. Her statements to the police are that she didn't remember the night before, right?
Yeah, she specifically said, I don't care.
She said, I don't care. I just wish I could remember it because it takes away all the fun, not being able to remember a single thing we did. And I only remember getting out of the car. So she was not upset in any respect about the sexual encounter the night before, was she?
No, she was very excited about it and very happy about the video when I sent it to her.
Judge, I offer the closure.
Okay, so let me just go through what the allegations are here. So the allegations are that she was beyond the point of consent. And what Mr. Bradel is arguing and Mr. Aidan Carney is arguing here is that she was happy about it and didn't mind that it occurred. But it's still illegal. if that happened, what is alleged to have been happened, and I tend to believe Lindsay over Aidan here. The attitude doesn't, it's the act that matters. So this is the same reason why if you're beaten up by your spouse and 911 is called and you say you don't want to press charges, charges are pressed anyway. Your attitude has little bearing. It's the act that breaks the law.
Put on that into evidence. Yes.
Any objection? Madam Plaintiff?
No, no.
This item will come in as exhibit.
And look how strong Lindsay is to do this. I wish she had gone with the receipts. You know, I wish she had talked to someone. What these kind of campaigns do is alienate you so you don't trust anyone else. At the time when you need the most support. So these campaigns are really, really damaging. And it's hard to listen to Aidan Kearney say, I was so damaged by this. I'm living in fear. Because that's what Lindsay Kearney is doing every day, living in fear. These campaigns, you're never the same after these campaigns. They alter you permanently. You're never able to trust another human being. If you're able to sort of, in the same way, if you're able to repair it at all, it's always that element is always, you're always suspicious of people, scared that something like this will happen again. You're very security conscious. Like I said, some people who I've talked to who've dealt with cults tape every single one of their phone calls, have security cameras, worry about their safety at all times. You're just never the same. So the worst thing that's been alleged that Aidan Kearney did to Lindsay Kearney is not so much the SA as it is, in my opinion, the vicious smear campaign against her. And he has people calling her the fake victim as he cries he's the real victim. Hard to take.
Number 5.
Yes, sir.
Any further redirect?
Just one moment, please, Your Honor.
Sure.
Now, in the district court, Mr. Carney, you were charged with assault and battery on a family or household or dating relationship person, correct?
I was.
And that case was taken to Superior Court, was it not, through indictment?
It was taken to a grand jury.
And after that, it went to Superior Court, correct?
I don't think it never made it that far
Well, not
because
the charge, the case in general, I'm talking, I'm sorry, I'll ask you a better question. The case in general was taken out of here to the Superior Court, correct?
yeah, 2 of the 3 charges ended up making it to Superior Court.
And with respect to the assault and battery charge, was there, again, from your knowledge of the discovery in the case, was there a request from the prosecutor, Mr. Novak, to obtain an indictment from the grand jury on the same charge from here, the assault and battery charge?
Yes, Mr. Novak asked the grand jury to indict me on assault and battery.
And in terms of the charges that emanated and were brought in Superior Court, did that assault and battery charge get out of the grand jury?
No, it did not.
All right. And you've seen the judge, just a little guidance from the court, if I may, Your Honor. I have one page from the grand jury, which ought to be impounded, I suppose, that corroborates my client's testimony that Mr. Novak asked for A and B indictment, and it was not granted by the grand jury. And I also have the docket from that case in Superior Court, which lists the charges with there's no assault and battery charge. So the grand jury did not find probable cause as to this very charge, which was the only charge anywhere in this entire record of this case that could ever be seen to support a 209A restraining order. So I would offer the docket and the one-page grand jury proposing it under impoundment to show, support, and corroborate the defendant's testimony that this charge was never even sustained as to probable cause in the grand jury.
May I see the
Yes.
documents?
For the record, Judge, I'm giving you the Superior Court docket on this case that emanated out of this court. There was no assault and battery charge, and just the one page of the grand jury where he asked for the indictment.
All right, so I think the docket is relevant and will come in. The grand jury minutes are not coming in.
Yes, sir.
Thank you.
So the docket, any objection to the docket? No, Madam Plaintiff?
Sorry, I know you're.
Okay, that'll come in as exhibit number 6.
Will do, Your Honor.
And your motion to admit the grand jury minutes this time.
Thank you. That's all I have. Thank you. Defense counsel.
Any recross?
No, you're not.
Okay. All right, thank you, Mr. Kearney. You may step down. Attorney Bradel, any other witnesses?
No, you are.
The rest of this
Thank you
time?
so much.
So this time, both parties have rested. We'll stop with
All right. Speaking of witnesses, let's get back to Mary Bagwell. Hey, Heisenberg says claiming to win a case when the other person didn't have an attorney is not a win. If she gets a good lawyer next time, everything changes. Hopefully. Hopefully. I hope in the meantime she can do what she needs to do to keep herself feeling safe. But I just wanted to show you Mary Bagwell. Innocence Fraud Watch wrote a excellent blog on it. So I wanted to share that. Wait, hold on one second. Let me make sure I have it up. Yes, I do. Okay. Hold on one second. Thank you for your patience. I just pulled it up and I was like, do I recognize this? Do I recognize what I'm pulling up here? Innocence Fraud Watch. Killer, Karen Reed retrial, liar, perjurer, fantasist, and fraudster. Innocence Fraud Watch always writes the longest titles, doesn't she? Mary Bagwell on January 7th, 2025, restraining order, renewal hearing for Aidan Turtleboy Carney and her ever-changing concocted story about Carrie Lama's pool party and her son Jacob, Part 3. Mary Bagwell cannot keep her fabricated story straight. On December 9th, 2024, Mary Bagwell alleged on YouTube live video that her son Jacob saved Lindsay Scattani's kid twice because she, Lindsay, was too busy gossiping about Aidan. Mary Bagwell stated, my son Jacob saved her kid, both of her kids, twice from drowning in Carrie Lama's pool. Twice I watched the kids. By December 12th, Mary Bagwell's fabricated story had morphed into something quite different. This is the third part on Mary Bagwell's perjury, by the way. So there's Ms. Bagwell stated that earlier in the evening she placed a call into a show she had been previewing. Ms. Bagwell stated to Martell that on the show, she explained to the show host where Kearney was not monitoring her child, at a family party that had occurred several years ago. Bagwell further mentioned on the show that Kearney's young child was discovered underwater in the pool and was recovered by Bagwell's teenage son. Miss Bagwell informed us that after the incident, Kearney was very appreciative of Kearney's son's quick response to recover the child from the swimming pool. This time, Mary Bagwell alleged to the Mansfield Police Department that Kearney's young child was discovered under the water in the pool and was recovered by Bagwell's teenage son. So within a couple of days, when Mary spoke to police, her fabricated story about her son Jacob saving these kids had been changed to a child, and of this child having been discovered underwater. On the 7th of January 2025, during a restraining order renewal hearing, Mary Bagwell's testimony, all I talked about was how my Son saved your children 3 times from drowning because you were too drunk and too intoxicated. So did all 3 children drown? Or is Mary Bagwell now alleging 1 child drowned 3 times? What kind of sick and twisted individual would make up such lies about a mother and her 3 innocent children? Note how Mary Bagwell alleged that Lindsay was too busy gossiping on December 9th, 2024, but by January 7th, 2025, Lindsay was now too drunk and too intoxicated. Son Jacob Bagwell, Mary Bagwell's son Jacob Bagwell, has seemingly yet to make an affidavit in support of his mother's sick and twisted fabricated allegations, and Jacob Bagwell did not support his mother's allegations during Aidan Kearney's restraining order hearing. Which story will Jacob Bagwell choose to tell the police? And will what he says match anything said by his mother or the other approximately 13 to 14 witnesses who were also in attendance at the pool party? 2 of Mary Bagwell's differing stories can be listened in the video clip below, but I actually have a version to bring up. Let me stop sharing. Pull it up.
My son, Jacob, saved her kids, both of her kids, twice from drowning in Carrie Lama's pool. Twice.
Yeah.
And I watched the kids because
Fuck her
she was too
donuts.
busy gossiping about Aidan.
All I talked about was how my son saved your children 3 times from drowning because you were too drunk and too
I'm asking you if you're aware
intoxicated.
that it's published.
So there we go. Quite a difference. Some discrepancies in her testimony there.
Counsel for the defendant, Attorney Gradle, I'll give you an opportunity to make a closing argument. The Madam Plaintiff, you get the last word, and I'll hear your closing argument as well. Thank you.
Judge, I appreciate the attention and the time you've given to this case. I'm not going to belabor the closing since it was the subject of your attention and scrutiny, as I saw. And I just want to say that there's no evidence here, Your Honor, that this plaintiff is reasonably in fear of imminent serious bodily harm. And more to the point, she's equivocating about being in fear of imminent serious bodily harm, where we see from her October 15th tweet, this is no shrinking flower. She is not afraid of Mr. Carney in any respect. She's always been the aggressor in this relationship. She's the one that threatens people.
Right. So she said, I'm not afraid of you. What is she supposed to tell him? I'm terribly afraid of you. She is tough. She's very tough. And by the end of this, she will be so strong. She will be like Superwoman. After going through this massive smear campaign led by Aidan Carney. She's going to be so tough.
When things get tough on her, she lashes back out. She doesn't shrink away, Your Honor. She threatens people. She told Mr. Carney that it was going to be the biggest regret of his life breaking up with her. I think the biggest regret of his life is probably going with her to begin with. And, you know, he's been suffering for this ever since. We have a very credible witness who came in here and told the court that, number one,
A very credible witness, just like Marie Russell is a very credible expert. Mary Bagwell and her switching stories.
Plaintiff recanted this bogus allegation, as minimal as it is, and as non-serious bodily harm as it is, that she recanted it, and she admitted to her that it didn't happen, and that once she kind of got that rock rolling down the mountain, that she wasn't going to change it, that she couldn't change it, and that is consistent with her character or her lack of character, her abusive, threatening way that she treats anyone that crosses her. And she continued that with Miss Bagwell when when she tried to express her opinion about some of the dangerous behavior, self-harming behavior that the plaintiff got into. You know, she got threatened up and down all over the place. And that's what this plaintiff has shown herself here to be, is someone who is the aggressor, who threatens. And when the machine of the government's 209A framework is handed to her, she uses it as a weapon. The only abuse in this case is her abuse of our 209A system, which is incredibly important for legitimate victims of domestic violence. And she's done nothing but secure the benefits of that through lies. She's uses it as a sword rather than a shield. She goes to where Mr. Carney is. It's no different than if Mr. Carney worked down the street at the Shell station in the garage, if she went down there to provoke him and antagonize him. She knows that Mr. Carney is working the Karen Reed case. She developed this phony interest in the case only to antagonize and further torment Mr. Carney. That's what the evidence here showed, Your Honor. It's high time that the court system, that Your Honor, the fact finder in this case, saw the case for what it is, which is nothing but a torture device for Mr. Carney. He has never put his hands on her. He never did any of the underlying actions here. And that said, Judge, I think that's overwhelmingly what the evidence shows. But even if it was one of those scenarios where us lawyers kind of take the truth of the matter asserted and just look at it that way, which I hate to do, but let's do it. Getting pushed on a couch over a year ago does not warrant this order today and now. That's the sort of the secondary argument, Judge, that, you know, we don't need to go into what happened, what didn't happen. I think the evidence is overwhelming that it didn't happen. But even if it did happen, it's not something that ought to support another year of a restraining order where she's going to use it and show.
There you go. So even if it did happen, even if you think it did happen, it's not worth another year of a restraining order. I thought she was never pushed down on the couch. Why even talk about it if it didn't happen? Why are we talking about things that didn't happen, Journey Brett? Bradle?
Use it consistently with the history she's already shown, how she uses it as a cudgel to torture Mr. Carney, to make him have to leave the courtroom, make him have to run away from her all the time. She's not afraid of, you're not afraid of someone, Judge, when you go to where they are. You're not afraid of someone when you generate 3 inches of antagonistic tweets and Facebook posts or whatever it is, criticizing him, antagonizing him, making false charges against him. She's trying to engage with him. She's trying to provoke a violation. So, Judge, here I ask the court to conclude that this plaintiff has zero credibility in terms of being a supposed victim. She makes a mockery of being a victim. She reaches out and tries to destroy people. And I hope that this...
She reaches out and tries to destroy people. There's only one person. Aidan Kearney, anyone? In his vicious blogs? To anyone the guy has 19 witness harassment charges against him. For anyone who dares say or has evidence against Karen Reed, they turn it right around and they accuse them of committing the crime. That is the way innocence fraud works. And Aidan Kearney has had a serious education. It is not to be underestimated, his education on innocence fraud. He knows how it works. He got it right away. You reverse, everything must be reversed. The victim is now the victimizer. Got to reverse everything. That's what he did in this hearing. That's how he runs his blog and runs these rolling rallies, all under the direction of Karen Reed and her lawyers. So let's not talk about destroying people. So that's how Aidan Kearney's made his living.
I have confidence that this court sees the facts of this case for what it is, and I ask that you vacate this order. There's no need for this order. There's no danger. The only danger here has been to Mr. Kearney's mental health based on all of her actions. So I would ask that you vacate the order. Thank you.
Thank you, Attorney Brady. Madam Plaintiff, this is your opportunity to make your closing whenever you're ready.
I just want to reiterate that I am in constant imminent fear of the defendant. That is a fact. Miss Attorney Brado has no way of getting inside my head and knowing what I experience every day. I'm a single mother of 4 children, very young children, and they live in fear. I am scared every day of my life when I wake up and I have to leave my house or send them to school. I'm terrified that he'll show up to their school or recruit one of his crazy fans to do something on his behalf. I'm constantly looking over my shoulder, worried about being followed. I have been followed numerous times. I'm worried without this order, there's gonna come a day where he's gonna get desperate enough to do something that there's no coming back from. My children, their lives have been severely impacted. I have developed almost an agoraphobia where I'm afraid to go out with them and bring them to the park. The only trauma, they were never woken up that night. That all of that was just a bogus lie concocted by Mr. Carney, and the only trauma they have is the trauma that they've seen as a result of what he's put me through, seeing their mother crying constantly because of the torment and harassment that he puts us through on a daily basis, posting my children's private probate documents and pictures of them online, and the threats, the phone calls, and I mean, I have panic attacks constantly. I'm in therapy. There's no doubt in my mind that if this restraining order is not renewed, he's going to ramp up his harassment, continue the stalking, and actually physically harm me to prevent me from testifying. He tried to prevent me from testifying and got the witness intimidation charges by bringing up private and probate documents from my past and threatening to publish those online and using his platform to do so. He has shown that his mental health is not stable. I don't know what he's capable of.
Right. It's not just what he does, it's what his flying monkeys do to please him. And she's had tweets all about her past struggles, things that are personal. So when you've had any kind of feeling of privacy or safety taken away from you, it's a basic need that we all have to feel safe and to guard our privacy. And Aidan Kearney knows the power of that. That's why he warns people he's going to write a blog about them. And people are scared. And you can hear, we saw a witness in the Karen Read case break down on the stand in tears over this. Over the Free Karen Read campaign led by Karen Read and Aidan Kearney.
I have to come back every year and face him, or I went to 2 hearings. I had involvement in or interest in the case long before I ever met him. That's how I met him, because
right, if she really wasn't afraid of him and wanted to keep him out of court, she would have been there every day at trial just to keep him out of the courtroom with a restraining order. 2 hearings is not long ago. She's not going to places where he is. You know, this fear seems, if Aidan Kearney really has this fear of violating this restraining order, which I don't believe he does, I just believe he wanted to win this hearing and to further his narrative. So if he can win this hearing, he's furthered the narrative that he's right and Lindsay's wrong. And that's what he's doing with the litigation, just like Scientology. The point is not to win. The point is just to keep Lindsay constantly engaged, broke, stressed out, so that she's holding on to her finances and her sanity by the thinnest of threads. That's the point here. And it's all about power and control, being the narcissistic psychopath that he is, in my opinion.
he was covering the case, and I bought a Karen Read t-shirt. That is how I met him. This wasn't me seeking him out. Mr. Carney has a history of doing this to multiple people. He has bragged about, I think he said, over 20 people trying to get orders on him and never once succeeding. And
There's the argument outside the evidence, Your Honor.
It's outside the scope of your objection sustained. You may continue your argument, but not on that topic.
okay, the order is not supposed to prevent me or stop me from living my life. And that's what he's been trying to make it do. I shouldn't have to stop the things that I'm interested in or not go to places. I mean, I lived in Denton my whole life. I mean, this is where I grew up. He lives in Western Mass. He comes out here, out this way. There's no reason for him to be out here. The rape investigation also is still open. I was informed by the Medfield detective just 2 weeks ago. And he says he wants nothing to do with me. He posted about me just 2 or 3 days ago, I think it was. Still posts about me to this day. He's the one constantly provoking and harassing. This is about power and control with him, and I've seen him do this to other people, and I just want to be left alone. I want to be able to resume some normalcy for my children and I, and that'll never happen if this order is not renewed. If this order goes away, there is not a doubt in my mind that this man who is hell-bent, has admittedly stated that he's hell-bent on revenge, is going to try to concoct something just like he uses his fans as a tool to be able to do so. And I would just ask that and one more thing I just want to mention, the restraining order violation. He did the right thing at first, leaving the courtroom. If he had just left the area and left completely, he wouldn't have been charged. There's no way to set somebody up. If you see them and you leave the area, that's what you do. He made a conscious choice to stay in the area, there's pictures of him in video, hiding in the bushes, following me as I walked to my car, filming me. I mean, he wrote a blog about me the next day using those pictures that he took. All he had to do was leave the area. I mean, there was nothing, the hearing was over at that point, and he made a conscious choice to stay. I just respectfully ask you, Your Honor, to extend this order and as the only means of trying to keep me and my children safe. That's all that I ask.
Thank you very much.
Thank you.
All right, so I'm about to render my decision, but before I do, I just want to caution all in the gallery. I heard a couple noises and some disruption during these proceedings. And I'm going to warn you now, decorum will be maintained. I don't want to hear any outbursts. I don't want to hear negative or positive outbursts. Okay, decorum will be maintained out of respect for both the plaintiff and the defendant. So I've had an opportunity to consider the evidence that has been presented before me, and I have to consider whether or not I'm going to extend this order. I find that the plaintiff has not met her burden and that there is not a likelihood of further abuse, and the order will not be extended and will expire at 4 p.m. today. Thank you.
Thank you, Your Honor.
There's not likelihood of further abuse. Depends what you call abuse. We'll see. Hopefully he'll behave himself. But then came the $2 million defamation. Emboldened by the going away of this restraining order, now he's sued her for $2 million for defamation. And good luck trying to win that one. I heard he's also trying to sue Jennifer Coffendorfer for saying that he was accused of SA. And I'm no fan of Jennifer Coffendorfer's, but I don't think so. I think that's just a fact there. I don't think he's got a leg to stand on. So that is what I have for today, guys. Please hit the thumbs up, subscribe to the channel, and I'll be back tomorrow at 6 p.m. Eastern. Have a great night, everybody. Going out with my hit single, I Hit My Boyfriend with My Car, my song about Karen Reed. Have a great night, everybody.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence. harassment, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit, yeah.